So welcome to Jumbo IS and welcome to lecture number 6 of this lecture series called Prelims Powerplay 2026. Now, as you all know, in this lecture series, we'll not only cover the entire year's current affairs, which will come in really handy for your prelims examination, but we will also cover all the important topics for your prelims. This lecture series is for revision of your entire UPSC syllabus for prelims. Okay, so make sure that you follow these 4 steps because this lecture series would come in useful, would come in handy only if you follow these golden 4 steps. Step number 1, watch the lecture. Step number 2, revise it from the notes and memorize it. Step number 3, ask your doubts in the WhatsApp groups. And step number 4, give the tests on time. Do these 4 steps till your prelims examination, and let me assure you, you will definitely succeed in your prelims examination next year if you follow this lecture series diligently. Okay? Alright then, let's begin today's discussion. Today is Polity lecture number 6 in this Prelims Powerplay lecture series, and today we are going to talk about judicial accountability. Now, why are we talking about judicial accountability? Well, this year, a big scandal broke out in India's higher judiciary. A justice of the High Court, Justice Yashwant Verma, at his residence, I would put this as delicately as possible, at his residence, some charred cash notes were found. There were quick allegations of corruption on this justice. This justice of Delhi High Court was quickly transferred, okay? But then the question arose of judicial accountability, okay? The problem is that our constitution has given a proper detailed mechanism of how to remove judges. There is a proper procedure of removal of judges, but it is a very difficult process. Now, because it is a very difficult process, despite the fact that there have been so many allegations against so many judges in the past, no judge has been impeached so far. No judge. Because the process of impeaching a judge is very difficult. To rectify this fact, Supreme Court in 1999 came out with certain guidelines to ensure judicial accountability. But still, the issue of judicial accountability or the issue of punishing erring judges, okay, judges who are accused of misbehavior or incapacity, this issue is still burning and it was a hot topic in this year's current affairs. Therefore, we will talk about judicial accountability. We will focus on judicial accountability in today's lecture. Now, basically, this lecture would be divided into 2 parts, okay? In part number 1, we will talk about the constitutional provisions with respect to removal of judges of higher judiciary. And when I say higher judiciary, I mean to say Supreme Court judges and High Court judges, okay? And the second part of this lecture would be dedicated to the Supreme Court guidelines of 1999 to ensure judicial accountability, okay? You have to be aware of these 2 facts because this was a hugely controversial issue this year and it has a high chance of featuring in your prelims examination next year. Alright? Okay then, let's quickly begin with judicial accountability. So yeah, Polity lecture number 6, judicial accountability. Now, like I said, we will divide this lecture into 2 parts. Number 1, we will talk about Constitution of India. Okay? Constitutional provisions with respect to removal of judges. And remember, we are talking about higher judiciary. Okay, and in higher judiciary, Supreme Court judges are there, High Court judges are there. Supreme Court and High Courts of India are called higher judiciary. And the second point would focus on 1999 Supreme Court guidelines. Okay, so without further delay, let's straight away jump into constitutional provisions with respect to removal of judges. Okay, all right then. So removal of judges. First, we'll talk about Article 124. First, we'll talk about removal of Supreme Court judge. Okay, so Article 124, Clause 4 deals with removal of judges of the Supreme Court. Clear? All right. Now, this article basically mentions the grounds on the basis of which you can remove a judge. You can only remove a judge of a Supreme Court on these 2 grounds. Okay. Ground number 1, proved misbehavior. If there are allegations of misbehavior against a judge and those allegations have been proven to be right. Or incapacity. Physical incapacity. Physically, the judge is suffering from various problems that he cannot perform his duties. Or mental incapacity. Okay? Only on these 2 grounds. Remember this, an MCQ might be asked. Remember, UPSC asks you questions, MCQs about minute details. So you should be aware of these minute details, okay? So grounds are proved misbehavior or incapacity. Simple. Now, Article 124 Clause 5 says that, well, Parliament shall or can regulate this entire process of investigating against a judge. So if there are allegations against a judge with respect to misbehavior or incapacity, those allegations should be inquired into, right? You should inquire into them, prove them whether they are right or not. Now, this entire inquiry procedure can be regulated by Parliament by law. Article 124 Clause 5 says Parliament by law can regulate the removal process, or basically the inquiry process. Okay, and for that Parliament did pass a law, and that is called Judges Inquiry Act 1968. Clear? Makes sense? So Parliament has by law regulated the entire procedure of inquiry. Remember, inquiry. Okay, the removal process is mentioned in the Constitution itself. Clear? Now, what is the removal process? We'll talk about this. But first, let's talk about High Court judges also. Okay, so the constitutional provisions with respect to removal of High Court judges is mentioned in Article 217, Clause 1, Subclause B, and Article 218. And both these articles say, simply put, both these articles say that the process will be same as mentioned in Article 124, which means the process of removing a Supreme Court judge is same as the process of removing a High Court judge. Okay, you have to follow all the steps when it comes to Supreme Court judges, and the same steps shall be repeated in the case of High Court judges also. This is mentioned in Article 217 and 18. Clear? Both these articles say that Supreme Court process will be followed, the process mentioned in Article 124. And Judges Inquiry Act 1968 applies to High Court judges as well. Make sense? Okay. Now, as per Judges Inquiry Act, okay, now, as per Judges Inquiry Act or as per the constitutional provisions, okay, basically the process, the detailed process of removing a judge is as following. Clear? First, if you want to remove a judge of the Supreme Court or High Court, a motion for his removal shall be initiated in either house of the Parliament. Okay, a removal motion signed by 100 members of Lok Sabha or 50 members of Rajya Sabha is given to the Speaker or Chairman. Clear? So if the motion is initiated in Lok Sabha, you need the support of 100 members. If it is initiated, remember, not passed, initiated in Rajya Sabha, then it requires the support of 50 members, and then it should be presented to Speaker in case of Lok Sabha, Chairman in case of Rajya Sabha. Clear? This is mentioned in the Constitution. Now, as per Judges Inquiry Act, once the motion is admitted by the Speaker or the Chairman, then a 3-member inquiry committee shall be formed. Okay, what is this 3-member inquiry committee? In this 3-member inquiry committee, a Supreme Court judge will be there, Chief Justice of a High Court will be there, and a distinguished legal personality, distinguished jurist, one who has legal knowledge, okay, judicial knowledge. These 3 people will be members of this 3-member committee. Then these 3 members would conduct a detailed inquiry into the allegations against that judge. Okay, the judge has the chance, will have the chance to present his side of the story also in front of this 3-member inquiry committee. All the procedure is, the entire procedure is laid out in Judges Inquiry Act. But remember this is the 3-member committee. If the 3-member committee finds that the judge is innocent, this motion will die out. Nothing will happen further. But if the 3-member committee finds out that these allegations are correct, then, well, the motion will go for parliamentary approval. Okay? Motion will go for parliamentary approval. The 3-member inquiry committee will say the judge is guilty. Now it is up to the Parliament. Whatever they want to do, they can do that. Simple. Now, in Parliament, well, each house of the Parliament should pass this motion, removal motion, by special majority. Now, by now, you should be aware of what special majority is. In yesterday's class, we discussed effective majority. We have talked about simple majority also. What is special majority? Well, 2/3 of members present and voting, those who are present and who are voting on this issue, 2/3 of them should say yes, the judge should be removed. And the total number of yes votes should also exceed 50% of the total membership of that house. So let's suppose if Lok Sabha has 500 total membership, okay, actually it's 552, now 550, okay, let's take 550. Just for simplicity, for mathematics, let's take 500, okay. So if Lok Sabha has 500 total membership, then 2/3 of the members present and voting plus the total number of yes votes should exceed 250, half of this. This is what special majority is. By special majority, it should be passed in Lok Sabha. By special majority, it should be passed in Rajya Sabha as well. Once that's done, then this would be given to the president. Okay? And the president has to sign on it. And the president, based on this, shall remove the judge. So the removing authority is the president, but the president can only remove if that motion is passed by the parliament. After passage, an address is presented to the president for removal in the same session and the president has to sign on it. Then the judge shall be removed. Now, as you can see, the process is really difficult. It is very difficult to get 2/3 majority vote. It is very difficult to get special majority in either house of the parliament. Both ruling party and opposition party have to be on board. Otherwise, if either of them would refuse to sign on this, well, the motion wouldn't pass. This is an extremely difficult process. And the process was made extremely difficult by design. The constitution makers wanted our judges to be independent, free from any problem created by a politician. They wanted them to be free from the fear of politicians, right? That is why they made this process extremely difficult. But because this process is extremely difficult, sometimes judges who should be removed can't be removed because the process is difficult. Yes, makes sense? So this is the situation. By the way, remember, in popular language, we use the term impeachment. That is in popular language, okay? In popular language, we say the judge has been impeached or an impeachment motion has been brought in for a judge. The Constitution doesn't use the word impeachment. The Constitution only uses the word removal. Impeachment is a popular word, not a constitutional word. Remember this part. Make sense? Okay? All right. Now, how many judges have been impeached so far using this methodology? None. But are there any judges of the past against whom allegations of misbehavior or incapacity were leveled? Yes. Motions for impeachment or removal were initiated against them? Yes. Now, what are those examples? Let's go through these examples. Examples of judges against whom these motions were initiated, removal proceedings were initiated. Okay. Now, the first one was Justice V. Ramaswamy in 1993, the first Supreme Court judge to face impeachment proceedings. The motion failed in Lok Sabha after it did not secure the necessary 2/3 majority. Everything was done. 3-member inquiry committee was also formed. This inquiry committee also said the judge is guilty, but opposition party members declined to vote. And in Lok Sabha, 2/3 majority was not sought. This was the case then. Justice Soumitra Sen, the first judge to be impeached by Rajya Sabha, he resigned before the Lok Sabha could vote on the motion. Okay. Against Justice Soumitra Sen, everything happened. The Rajya Sabha also gave special majority, 2/3 majority to remove this judge. But before this motion could go to Lok Sabha for 2/3 majority, he resigned. So it died. Then Justice P.D. Dinakaran, the Chief Justice of Sikkim High Court, resigned ahead of impeachment proceedings. Okay, he knew that impeachment proceedings are being initiated against him, so he resigned beforehand. Then Justice G.B. Pardiwala in 2015, Justice S.K. Ganguly in 2017, Justice C.V. Nagarjun Reddy, Justice Deepak Mishra. Well, the chairman of the Rajya Sabha rejected. So 50 members of Rajya Sabha initiated the motion in Rajya Sabha, but the chairman of Rajya Sabha rejected that motion. And the latest one is Justice Yashwant Verma. Okay. Now, as you can see, it is very difficult to remove a judge, despite the fact that Judges Inquiry Committee, the 3-member Judges Inquiry Committee has proved that yes, the allegations against these judges are true. Most of these judges, not all, most of these judges, they are true. Yet, it is very difficult to secure special majority. It is very difficult to basically remove a judge. And that is why many people say that now judges think, some who are corrupt, okay, some, not all. Some judges think that because it is difficult to remove them, well, they go on with their business of misbehavior or misbehavior without any fear because they know that they can't be removed, right? Therefore, to stop this, because if you can't hold judges accountable, then the entire institution of judiciary is put into question, right? You have to hold judges accountable. But the accountability is very difficult in the Constitution. Special majority is very difficult. So the Supreme Court, realizing this fact all by itself, that yes, it is difficult to ensure judicial accountability because the procedure is very difficult. Okay? Therefore, they created their in-house procedure, their in-house mechanism to ensure judicial accountability. Okay? Now we need to be aware of this in-house process as well. Okay? So let's talk about this in-house process separate from this impeachment system in Constitution. Clear? So, Supreme Court guidelines which were released in 1999. Now, these Supreme Court guidelines were of two parts. Okay, judicial accountability, 1999 Supreme Court guidelines. One set of guidelines were for this in-house procedure. Within Supreme Court will try to investigate the entire matter, okay, within Supreme Court and see what they can do, what punishment they can give to a judge, okay. And then the second set of guidelines were for judges. Judges have to abide by these guidelines so that everyone has confidence in our judiciary, that everyone feels that our judges are not corrupt at all. So one set of guidelines were for investigation, in-house investigation. The other set of guidelines were for judges themselves. They have to follow this. Okay. So first let's talk about this in-house procedure. Okay. What is the purpose of this in-house procedure? To deal with allegations of misconduct against a judge. What is the process? Once there are serious allegations against a judge of a Supreme Court or a High Court, the Chief Justice of the relevant court, if it is the Supreme Court, then Chief Justice of India. If it is a High Court, then Chief Justice of that High Court can set up an inquiry committee comprising of 3 judges. And these 3 judges will inquire into these allegations. Okay? If they find that the judge is innocent, okay, done deal. But if they find that the judge is, well, the allegations against him are true, then what is the outcome? Well, they can ask the judge to resign. That particular judge, they will ask him to resign. If the judge is defiant, if he's not resigning, then what you can do? Well, then you can recommend the president or the prime minister to initiate the constitutional removal process, Article 124 or 217. So if you're not resigning by yourself, then the Supreme Court or the High Court will recommend to the president or the prime minister to initiate the proceedings, constitutional proceedings. Clear? This is the in-house procedure. Now, this is the in-house procedure, but there are certain criticisms against this in-house procedure which you should be aware of. Okay, what are those criticisms? First of all, they say that this is an extra constitutional mechanism. Okay, extra constitutional. I mean, there is no law with respect to this. There are no provisions in the Constitution with respect to this in-house procedure. The Supreme Court just created it out of thin air. It is not constitutionally backed or legally backed. So it's an extra constitutional mechanism, and that is why people basically criticize it. Then there is lack of due process or safeguards. Judges Inquiry Act 1968 has a lot of safeguards for the judge against whom the inquiry has been initiated. There are no such safeguards in this in-house procedure. Then if you find that the charges against the judge are serious and they're true, you can ask the judge to resign. But what if the judge says, I won't resign? Then what will happen? Okay, then the matter will go to Parliament. So the accountability is not properly ensured. Plus, if there are serious allegations of corruption against a judge, the maximum punishment he can get is that he'll resign. So some people say that the punishment that the judges are getting is not enough given the nature of their misbehavior. So this is also one issue. So these are some of the issues. Okay, this is the in-house procedure. Clear? Now let's talk about, well, Judicial Code of Ethics. Okay, remember I told you another set of guidelines for judges to follow. Judges have to follow this. So these guidelines are Judicial Code of Ethics. Okay, now what is there? Well, the purpose is the Supreme Court in 1997 provided a 16-point guidelines, 16 guidelines for ethical conduct of judges. Okay. The scope was that these guidelines, these 16 guidelines apply to Supreme Court and High Court judges. And how to ensure that these guidelines are followed by judges? Well, if the judges are not following these guidelines, then the in-house procedure, Remember, this in-house procedure can be initiated against that judge. Clear? Now, these guidelines were adopted by Supreme Court of India in full court meeting in 1997. Just remember this part, okay? Now, remember this fact about Judicial Code of Ethics. These are 16 guidelines, okay? You don't have to remember all the 16 guidelines, but just remember some of the guidelines, okay? Some of these guidelines are given here. So, judges have to follow them. You don't have to remember those 16 guidelines. Nobody would ask questions on them. But, for example, a judge shall not speculate in shares and stocks. Judge should not engage directly or indirectly in trade or any business. Judge should not seek financial benefits, corruption basically, money. Judge should not ask or accept contributions or bribery. Judge should not act in any way that could affect public confidence. So these are some of the ethical guidelines that judges should follow. Clear? Now, in-house procedure was launched against Justice Verma, okay, Yashwant Verma. Nothing happened, okay, he did not resign. Now, impeachment proceedings or removal proceedings against him have been initiated in the parliament. Let's see what happens. All right? And that would be all. With that, we conclude this topic of judicial accountability. I'm sure it has added value to your preparation. It has definitely added value to your preparation. Now, you just have to follow these 4 golden steps. Watch, revise, ask your doubts, and give the test on time. Do this till the end of your preparation, till your prelims preparation. Okay? At least till April next year. Do this. Follow this lecture series properly. And I assure you, it will really help you out. Okay? So you have watched this lecture. Now revise it from the notes and ask your doubts in the WhatsApp groups. On that note, I'll be signing off with the promise of seeing you again with another topic in the next lecture. Thank you, everyone.